Distinguished speakers and guests, dear colleagues, dobre jutro. It's a real honor to participate as President of the European Court of Human Rights in this, the second Gender Forum of the Western Balkans. And I'm sure I speak for all present when I thank the AIRE Centre, the UK government, but also Biljana and her team for the fantastic organisation. The purpose of the forum today, and indeed last year, is to cast light on the continued need to promote gender equality and to tackle bias, discrimination, and violence against women and girls in our societies. These issues and a lack of progress in their regard are not unique to the Western Balkans, as I emphasised last year in Budva and as the previous speaker just mentioned. However, they are acute enough and of a particular nature in your region to warrant the gender network and all that it entails. The focus of the forum and of the gender champions in the judiciary network, which you will develop further tomorrow, needs to be on two opposing, and in the 21st century, let's face it, contradictory sides of the same equation. First, promoting women's universal and inalienable right to equality, and second, protecting women and girls from abuse whose forms are universal, age-old, and which show no signs of abating. This morning, my keynote will focus on the more positive side, namely gender equality. Since one of the aims of the network is to secure social, economic, and cultural empowerment of women, this focus is essential. My brief overview this morning will concentrate firstly on the equality and non-discrimination tools available under the European Convention of Human Rights. And secondly, I'll provide some case law examples showing how the court has grappled with gender equality, and I use the verb grapple on purpose. I had hoped to touch on some Protocol 12 cases, but we're already a little bit over time, and I don't want to deprive you of the time and expertise of the panels. And finally, I'll touch briefly on questions of positive discrimination and intersectional discrimination. Let me begin with a few more general introductory remarks. More than 10 years ago, in the important case of Konstantin Markin against Russia, the Grand Chamber in Strasbourg held that the advancement of gender equality today is a major goal in the member states of the Council of Europe. This goal was again referenced in the 2022 judgment of the Grand Chamber in a case called Bieler against Switzerland, to which I'll return later. And last month, 46 heads of state and government came together in the land of ice and fire, Iceland, the homeland of your network's new patron, for only the fourth summit in the history of the Council of Europe. They adopted a declaration which covered many points, but amongst them they said, and I quote, "Gender equality and the full, equal and effective participation of women in public and private decision-making processes are essential to the rule of law, democracy and sustainable development." We can agree that there is political will across Council of Europe member states to promote gender equality and effective participation. However, to achieve substantive and not merely formal equality, to dispel the notion that the right of all to equal protection is sufficiently served when we merely tackle abuse, one needs to alter traditions, habits, attitudes. Such changes are generally met by resistance, structural resistance within some societies, and even backlash against progress once attempted or achieved. As the 17th President of the European Court of Human Rights, and its first female president since its establishment of the court in 1959, I can attest to resistance meeting the changing face of my profession as part of my own lived experience. And I imagine that most women in this room can attest to exactly the same thing. Out of the 46 sitting judges, 17 are currently women. One section president out of 5 is a woman. The figures fluctuate depending on the arrival and departure of judges, and moreover, the court is dependent on the election from the list of candidates which the member states present to the Parliamentary Assembly. However, it's worth noting that when the court celebrated its 50th anniversary in 2009, the number of female judges on the court was the same as it is today, 17, up from a previous low of just 8, or just 19%. It's essential for the legitimacy of our justice systems and our courts, whether national or international, that they reflect the populations which they are called upon to serve. Gender is just one part of this complex equation. But since, regardless of age, skin color, socioeconomic status or education, we represent 50% of the population, it is a vital component. We are not born vulnerable or underrepresented. We are made vulnerable and underrepresented. One, of course, cannot assume or expect that women on the bench will judge certain issues in a particular or gendered way. However, it is far more likely, given their lived experience en route to the bench, and I would add, while serving on the bench, that they will at least recognize structural issues of discrimination and inequality, and in this way ensure visibility in their regard as a matter of public debate. In the words of Catherine McKinnon, you can't change a reality which you cannot name. Turning to the equality and non-discrimination tools available under the European Convention on Human Rights, as you know, the Universal Declaration of 1948 was the inspiration for the European Convention. The Universal Declaration provides in Article 7 on non-discrimination, and I quote, "All are equal before the law and are entitled without discrimination to equal protection of the law." However, Article 14 of the Convention doesn't mention equality of treatment or equality before the law. It only prohibits those forms of discrimination which hamper the equal enjoyment of substantive rights enshrined in the Convention itself. In addition, the Convention can be used to counter differential treatment only when Article 14 is engaged. The fact that Article 14 is a non-discrimination instrument and not a standalone one influences how it has been used and what it has been achieved. Protocol 12, which is standalone and which does provide for a general prohibition of discrimination, prefaced by a preamble alluding to equal protection before the law, has given rise to relatively little case law to date, as it has only been ratified by about 20 states. The limited focus of the Convention and the limited focus of Article 14 and its place in the Convention architecture explain why I would also highly recommend you to draw inspiration from the developed provisions of EU primary and secondary equality law and corresponding case law of the Luxembourg Court. The increasingly constitutionalized nature of the EU legal order provides for strong equality clauses in the Charter, for equality as an EU value in Article 2 of the Treaty on European Union, and even for gender mainstreaming. For all states now candidates for EU accession, EU equality law is not only a treasure trove when it comes to the legal empowerment of women in social and employment spheres, it will be a legal obligation as part of the incorporation of the EU's acquis to amend national legislation accordingly on the road to accession. The Strasbourg Court has, for its part, dealt with a number of important cases concerning a variety of issues relating to equality between men and women, not all of them brought by women. It may seem counterintuitive that the two Grand Chamber equality cases I mentioned in my introduction were lodged by men. However, one thinks back to the litigation strategy of, amongst others, the Supreme Court judge previously mentioned by Commissioner Jankovic, who advanced gender equality by challenging rigid, gender-based classifications which harmed men, like the two fathers in Constantine Marken and Bieler. The relevant point is not whether an applicant is male or female. It is to examine whether the legislation or decisions challenged perpetuate a traditional distribution of the roles of men and women in our societies. In these two cases, we see men locked by law and by society into a role subsidiary to that of women in relation to the exercise of their parental duties. The Strasbourg Court has repeatedly held that differences based exclusively on sex require, and I quote, very weighty reasons. Where a difference in treatment is based on sex, the margin of appreciation afforded is, as you know, narrow. References to traditions, general assumptions, or prevailing social attitudes in a particular country are insufficient justification for differential treatments on grounds of sex, and the Court has consistently rejected them. Our case law deals with differential treatment as regards the entitlement of men and women in the allocation of social security benefits, in relation to inheritance, rights to parental leave, other employment-related benefits, as well as other forms of discrimination mostly affecting women, such as the impossibility for married women to use only their maiden name in official documents. Many more examples can be found in the excellent guide to our case law, which was prepared last year by my good colleague, Judge Ivana Jelic. Turning to some recent examples where the court has responded to gender equality arguments under Article 14 in conjunction with another substantive article, they demonstrate how discrimination claims arise in multiple ways, some of which may seem trivial at first sight, but which generally reflect structural and at times deep-rooted inequalities in society. In Leon Madrid against Spain, the applicant mother, in a paternity suit, recognizing her former partner as the father of her child, had requested the Spanish courts to reverse the order of the surnames under which her minor daughter was registered. The court found that a number of social changes had taken place in Spain since the legislation applicable in her case had been adopted in the 1950s. The effect of those changes was to bring domestic law in other respects into line with international instruments and abandon the patriarchal concept of the family that had been predominant in the past. While the Strasbourg court accepted that the impugned rule might prove necessary in practice and was not necessarily incompatible with the Convention, and this is a recognition that we are not a constitutional court, nor do we deal with legislation in abstracto, it held that the inability to derogate from the rule, regardless of individual circumstances, was excessively rigid and discriminated against women. My second example is the case of Tapieva and others against Russia. The mother applicant had complained that the domestic authorities had failed to take reasonable and timely measures to reunite her with her daughters who had been kidnapped by their paternal grandfather on the death of their father. Domestic court judgments in her favor had remained unenforced, and subsequent judgments in favor of the grandfather disregarded the clear provisions of applicable domestic law. Under Article 14, in conjunction with Article 8, she argued that this failure had amounted to discrimination on grounds of sex, and she sought in her complaints to demonstrate the overtly discriminatory policies and practices in the region, as demonstrated by statements made by high-ranking officials and by a report from the UN CEDAW Committee, which had referred to the fact that it was deeply concerned, and I quote, at the regulation of family relations in the Northern Caucasus, where the concept of ownership of the father over his children continues to reign, leading in practice to situations in which women lose contact with their children after divorce. The court found in favor of the applicant mother. No reasonable justification had been provided by the Russian Federation. Indeed, the Russian Federation had contributed to and even legalized an unlawful situation in which the mother of the children, as a result, I quote, of gender stereotypes and prevalence of customary patrilineal practices in the region, had been deprived of her right to raise and educate her children. In this Russian case, we see the importance of international monitoring and reports as evidence of structural discrimination. This is a point echoed in many of the gender violence and femicide cases which you'll discuss later this morning, in which Article 14 is raised. The third case I would mention is a case called Demici against Turkey, in which the national judge elected in respect of Turkey participated. It concerned the application by the Turkish courts of a statute of a 16th century private foundation. The applicant's mother, who was a direct descendant of the founder, had been refused, because of her gender, to entitlement to income and deprived of the possibility of transmitting to her children the status of beneficiary. When assessing lawfulness, the court considered that the founder's wishes could not guarantee primacy when compared with current standards of public order and the Convention. The Turkish government had also argued that the wishes of the founder ought to prevail as the matter was a private law dispute. But the court importantly rejected this logic, as it would be tantamount to rendering meaningless and even denying the existence of positive obligations requiring states to prevent, put an end, and sanction discrimination. The violation found, however, was limited in its temporal scope for reasons of legal certainty. And while this was understandable in the circumstances of that case, I think it's important to stress that such temporal limitations in judgments in the socio-economic sphere can often lead to a considerable delay in the equalization in monetary terms of rights, and this phenomenon is particularly noticeable in the sphere of pensions. Returning to the Grand Chamber judgment in Bieler against Switzerland, the court found in this case a violation of Articles 8 and 14 due to the termination of a widower's survivor's pension when his youngest child reached 18, an event which did not lead to the termination of the pension for a similarly situated widow. The case is interesting because it demonstrates how the perpetuation of traditional roles damages society generally, not just women, because it also points to how legally and socially difficult it can be to move society's dial in relation to parenthood and expected roles on the employment market, even in one of the world's most successful economies. The Swiss Federal Court, although not finding in favour of the applicant, had recognized that the law established an unacceptable distinction on grounds of sex. However, since revision of the social security system had repeatedly failed over many years, the National Court was required by the Constitution to apply the discriminatory law. Pointing to cases such as Petrovic and Konstantin Markin, the Court emphasizes that contemporary European societies had moved towards a more equal distribution of responsibility between men and women for the upbringing of their children, and that there was increasing recognition of the role of men in caring for young children. The Swiss government could not rely on the presumption that a husband supports his wife financially, in other words, the male breadwinner model, in order to justify a difference in treatment that put widowers at a disadvantage in relation to widows. The domestic legislature was considered to have made a distinction on the basis of sex, which was not necessary for either biological or functional reasons. As regards, finally, positive discrimination and intersectional discrimination, while it's not for the court to pronounce on the desirability as a matter of legislative policy of positive discrimination, and while it has not yet had to develop a general or robust theory of positive discrimination, the basic elements are there in our case law. Article 14 doesn't prohibit a state from treating groups differently in order to correct factual inequalities between them. In certain circumstances, a failure to correct inequality through differential treatment may in itself give rise to a breach of Article 14. In an appropriate case, it would be important to see the court engage with two notions, the attainment of equality of results or representation, and equality of opportunities, which fuel debates on positive discrimination before national courts and before the other European courts. In the case of Anderli against the Czech Republic, which was decided in 2011, the applicant, a father, complained of the difference in pensionable age for men who had raised children compared to women. He sought to retire at 57, while the law at the time provided for retirement for men at the age of 60. The Strasbourg Court found no violation of Article 14 of the Convention in conjunction with Article 1 of Protocol 1. It accepted that the impugned measure pursued the legitimate aim of compensating for factual inequalities and hardship arising out of the specific historical circumstances of the former Czechoslovakia, where women had been responsible for the upbringing of children and for the household while being under pressure to work full-time. In such circumstances, the national authorities were considered better placed to determine the moment at which the unfairness to men began to outweigh the need to correct the disadvantaged position of women by way of affirmative action. 12 years on, I think it's important to consider whether the court nowadays would accord a state as wide a margin of appreciation as it did in this judgment, a judgment which was criticized by some for actually reinforcing gender stereotypes or demonstrating a form of benevolent sexism. But we know that on measures of positive discrimination, lawmakers, judges, and indeed academics are often divided. Regarding intersectional discrimination, we have, of course, the very interesting case of Carvalho Pinto de Sousa Moraes from 2017, which was referred to last year at the first Gender Forum by my predecessor. The case concerned a decision of the Supreme Administrative Court of Portugal to reduce the amount of compensation awarded to the applicant, a 50-year-old woman suffering from gynecological complications as a result of a medical error. The operation had left her in intense pain, incontinent, and with difficulties in having sexual relations, and she alleged that the reduction in the amount of compensation was discriminatory because it had disregarded the importance of sex for a woman of her age. What I find interesting in this case is a passage which I'll quote from the court's judgment. The Chamber held, "The question at issue here is not considerations of age or sex as such, but rather the assumption that sexuality is not an important factor for a 50-year-old woman and mother of 2 children as for someone of a younger age. That assumption reflects a traditional idea of female sexuality as being essentially linked to childbearing purposes and thus ignores its physical and psychological relevance for the self-fulfillment of women as people." What is interesting to note in this case, notwithstanding the dissenter's criticism of the narrow comparative case law on which the Chamber relies, is the fact that they touch not just on the combination of gender and age, but also the Chamber moved away partly from a discrimination assessment requiring causal effects and comparisons and honed in on invidious prejudices and stereotypes which might escape a classic discrimination analysis. Having been asked to dedicate my intervention to gender equality, I cannot sadly but conclude that neither Article 14 nor Protocol 12 of the Convention have produced to date the kind of robust, far-reaching anti-discrimination, never mind equality jurisprudence, that some might hope for, leading rapidly to an integrated systemic way to systemic empowerment and effective participation of women. And I think there are a number of reasons for this. Firstly, the original and enduring conception of the European Convention, as represented in Article 53, is to provide a minimum level of protection of fundamental rights and freedoms. The Convention, like many pieces of legislation, seeks to protect individual rights. But in this field, all too often, we have to remember that the disadvantages suffered are usually collective and structural. They may be very difficult for an individual applicant to prove. Secondly, the accessory character of Article 14 has limited the protective scope of Strasbourg anti-discrimination law. Article 14 is sometimes treated as a subsidiary claim by the court, which concentrates its analysis on the substantive articles relied on. And this pattern is also evident in the gender and domestic violence cases, which you will discuss later this morning. And as I suggested last year when I addressed that specific topic of domestic violence, this approach can sometimes lead to an excessively muted judicial response in cases of that nature. Thirdly, in performing the justification test, our court allows states a certain margin of appreciation, even in discrimination cases, which has perhaps enabled states, particularly in relation to the all-important socio-economic rights, to preserve the status quo. And some of the judgments I've mentioned, such as Anderlecht, bear this out. Fourthly, the fact that social and economic rights are not directly guaranteed under the Convention points to why our case law on employment and social security benefits is more scarce than that on gender-based violence under Articles 2 and 3. For at least 27 of the Council of Europe's 46 states, combined with EEA states, extensive legislation regulating women's social and employment rights have led to transformations of many societies, including my own, Ireland, not least due to the social and economic empowerment of women. But cases from those states go to the other European courts. With this appraisal of the Convention's record, I don't want to discourage those who look to Strasbourg for guidance and light in relation to the social, economic, and cultural empowerment of women. At the end of the day, we are dependent on the types of cases which are being litigated at the domestic level and on valiant litigants and their lawyers bringing those cases afterwards to Strasbourg. The Court's knowledge-sharing platform gives easy access to our non-discrimination arsenal, and it is not without considerable substance. In a case like Bieler, execution of the judgment of the Court by the Committee of Ministers should achieve what decades of successive legislative reforms failed to do in Switzerland. The cases which I have addressed show you that litigants have at their disposal a vast array of international, EU, and Convention case law, which combined, and I would stress the word combined, make for a very powerful basis to plead for individual and societal changes. In addition, This forum and the discussion it promotes amongst judges, practitioners, academics and civil society are crucial in that they point to key areas in which we know, or as Strasbourg judges, we discover that we must do better. I know that my present and former colleagues from the court will now take up where I leave off. But before they do, I would like to salute all the gender champions in this room today. It is I who thank you for having given me, in the name of the European Court of Human Rights, the opportunity to address you this morning. Hvala.